I'm here with Michael Becker, one of the top criminal defense lawyers here in Nevada. And Michael, today I want to talk about possession of child pornography. What does Nevada law say about child porn?
Well, Nevada has very stringent laws in regard to the possession of child pornography. If you are found to be in possession of child pornography, you can be sentenced as a felon to between 1 and 6 years in prison for each image of child pornography that you possess.
And what is the definition? I mean, what constitutes child pornography in Nevada law?
In Nevada, child pornography is having visual images of children under the age of 16 engaged in sexually provocative activity.
So when you say images, that could be video, that could be print images, that could be images on the computer.
That is correct. And it doesn't necessarily have to involve children engaging in acts of sex. It could be children in sexually provocative positions. It's something that's litigated that you can argue to a jury, this is sexual, this is not sexual.
Now, what if it's just, let's say, somebody having images of children that are naked, and they're not doing anything sexual, it's not sexually provocative stances, but it's just a lot of images of naked children. Would that constitute child pornography?
It would depend on the circumstances. I mean, I think that parents take pleasure in photographing their children. A lot of parents would take pictures of the children naked, pictures of the children in the bathtub, pictures of their children dressing. I mean, we all probably enjoy looking at pictures of ourselves as kids, and sometimes we see a picture of ourselves naked, and it's clearly not something that's sexually explicit or provocative. It would depend on who possessed the images, and that would largely dictate how a jury would interpret whether they were sexual images or whether they were appropriate images.
So it really depends on context then. I mean, if it's parents having images of their children, and that's benign, that's appropriate in our culture. But let's say it's some 50-year-old man who has no children and has 500 images of kids, of various, children that are naked. Then in that context, even if it's not sort of sexually provocative pictures, just the mere naked pictures might be prosecuted?
That is correct. And it might also depend, for example, on how the pictures are stored. A lot of the times when we represent people who are charged with child pornography, there have been search warrants that have been executed, computers seized, and the files are stored someplace on the computer. So, for example, if you had a file that contained pornography and there were pictures of naked children in that same file, one might suggest that the files were stored there because those were your sexually explicit files. So all of the facts and nuances could affect how a prosecutor would view whether or not to to file charges against someone for possession of child pornography.
Let me ask you about the issue of age, because I know the age of consent here in Nevada is 16 for having sex, which is different than a lot of states. I mean, in most states it's actually 18. But you said that the sort of age threshold for child pornography is also 16. So, I mean, the definition is these sort of nude, provocative pictures of children under 16, right?
That is correct. Now, in Nevada, if the images are of children under 14, the penalties are more severe, but it's still considered child porn if it's 16 or under. Does that mean that you can have pictures of 17-year-olds engaging in sexually explicit acts? Not necessarily, because federal law defines age of majority at 18. So under federal law, pictures of a 17-year-old engaging in sexually explicit activity would still be considered child pornography, and you could face federal prosecution for possessing those images, even if the state chose not to file against you.
Now, let me ask you, how is age determined, though? Because I'm assuming a lot of times the police confiscate child pornography, and it's not clear. I mean, it's a teenager, but that teenager might be 17, might be 18, might be 15. It's sort of ambiguous. How is it determined if they can't really sort of trace the person who's depicted and verify that for certain?
There are a variety of ways. There have been incidents where law enforcement agents are actually able to investigate and find the person that's depicted in the image. And they've been able actually to age a certain photograph or image. Sometimes federal agents will have photos out there that people will find on the internet, and they know exactly how old the participants are. And once they find you in possession of those materials, they can date it with precision. Other times, it's simply a matter of looking at the photographs and forming an assessment. Does this person appear to be underage? And sometimes you're looking at the development of the subjects in the picture. You're looking at whether there's pubic hair, for example, and it could be that they have an expert witness testify and give age approximations, or ultimately that would be a question for a jury. So the jury would take a look at the images, and if the jury felt beyond a reasonable doubt that the participant was underage, then they would find a conviction. More often than not, if age was ambiguous, the prosecutor might choose not to file. But when we see these cases prosecuted, most of the time when you look at the images, it's very clear that you're dealing with minors.
So, Mike, let's say you have a situation, and I'm sure this is not uncommon, where the cops go to somebody's house, they seize a bunch of images on a computer of child pornography. There's 5 or 6 people that live there, and they have a suspect who they think it belongs to, but they can't prove. What do they do to try to coax an admission from that person, or really nail the one individual they suspect?
In almost every scenario, what they do is they, in essence, threaten to arrest everybody unless the person who it belongs to steps forward. And remarkably, in almost every scenario, the person who it belongs to steps forward and says it's mine in order to protect others from being arrested. But what's important to know is this. One, it's an idle threat. I've never seen a situation where the police actually arrested everyone in a home where child pornography was found. 2, you don't need to incriminate yourself. You have Fifth Amendment rights, the right against self-incrimination. There's no need to make an admission. In fact, you shouldn't make an admission. You should assert your rights, and you should take the Fifth.
As a general matter, I mean, anytime you're suspected of a crime, you should never talk to the police without a lawyer, right?
That is correct.
And this is certainly, one example where you never should.
That is correct. I would note also that we've also seen situations where somebody stepped forward and said, the pornography is mine, even when in fact it wasn't, but they may have had elderly parents, for example, and they didn't want to see their parents getting arrested. So they make a false confession regarding the possession of child pornography to avoid seeing others get arrested. So
take the rap for someone else.
That's right.
Now, in terms of defenses, what about search and seizure? I mean, if the police suspect that someone is downloading images of naked children, do they have a right to sort of raid their house and seize their computers and go through their personal files, or does that violate their privacy?
An individual has the right to be free from unreasonable search and seizure in their home. And what that means is that the police just can't come to your house and come, storming in and seize your computer, except in 2 circumstances. One, where the police have a search warrant signed by a judge. And of course, if the police come to your house with a warrant, you should allow them to act in furtherance of the warrant. But if they come to your house without a warrant and they say, hey, we would like to take a look at your computers, may we do so? Absolutely. An individual has the right to deny consent, and as an attorney, a defense attorney, I would absolutely advise people not to give consent to search. If the police come to your home to search and ask you for your consent, what you should do is you should call a defense attorney right away, not give consent.
So let's say that the police do violate someone's right and they don't have a warrant, or the warrant is defective, and they go and seize their computer and seize images of child porn. Is it possible to get cases like that thrown out because the police violated their rights?
Absolutely. Defense counsel would file a motion to suppress the evidence, and if they could convince a court that the evidence was obtained unlawfully, the judge would be bound to throw the evidence out and ultimately dismiss the case.
And that would be a best case scenario, obviously, for the client.
Absolutely.
So, Mike, I guess the take home for our viewers is this, that someone who gets arrested for this crime, often is very demoralized and embarrassed and humiliated and has a sense like my life is over. But that's not always the case. I mean, a good criminal defense lawyer here in Nevada can do a lot to help someone charged with this in terms of getting the charges reduced or dismissed or avoiding being a sex registrant.
Absolutely. As a matter of fact, when I defend people who are charged with possession of child pornography, the greatest challenge is often an emotional one, getting them ultimately to reconcile their behavior, to forgive themselves. Sometimes, in fact, the courts are more forgiving than the individual. We often get results where a person is placed on probation, has no jail time, and is ultimately able to clear the child pornography charge off their record.
And here at Las Vegas Defense Group, we've had a lot of success in doing that.
Absolutely. I'm Michael Becker, an attorney with the Las Vegas Defense Group. If you're under investigation for possession of child pornography, call me and we'll talk about what we can do to get your charges reduced or dismissed.